Yeah.
But wait till you hear about the employment law changes.
I have so many questions. Oh my God. I am so glad we're doing this. And
Yeah.
I'm gonna like spend all night tonight editing so I can pump it out this week because people need to hear you.
Unbeknownst to most people in Ontario, the Ontario government dropped a bomb on employment lawyers and any employer in Ontario, believe it or not. It was done on Friday, last Friday, which was, so May 26th. So
Okay.
the government came on May 26th in the afternoon on a Friday on the pandemic,
On
during the
purpose.
pandemic. Maybe, I mean, so they did a press release, the following Monday, and they went back in time and retroactively dropped a bomb on what everyone thought was the rules around temporary layoffs in Ontario and constructive dismissal under the Employment Standards Act. So those are the two things, the two kind of heads that we could talk about today, which is if a dentist has laid off an employee as of March 1st, the law says they were not actually laid off. The law says they were placed on a temporary, job-protected leave of absence. The government has said if a dentist or any employer put an employee on layoff as of March 1st of this year, it is technically considered a job-protected, unpaid leave of absence.
So what does that mean exactly?
So that means that a dentist can keep their staff off work, unpaid, for the entire duration of the emergency, as declared by the government, plus an extra 6 weeks. So what the government is saying is the emergency is going to last for as long as it's going to last, but you have an extra 6 weeks to ramp up, to get your PPE ready, and to get ready for all of your employees coming back to work. So this is, in my opinion, it's never been seen in employment law. Normally, lawyers, and employers get a few months of notice. When minimum wage was switched from $15 to $14, the Doug Ford government gave us about 3 months, and that was considered quick. This is going back in time 3 months to say if you laid off an employee, it does not have to end at 13 weeks. So there will be no mass terminations of employees just because you laid them off.
So basically, since we don't know what the entire duration is, if the entire duration ends up being, say, October 3rd, then we've got 6 more weeks after that to figure out where we're at, basically.
Right, and to bring back all of your employees back to work.
But then that's a whole other conversation I want to have.
Yes. Now, I suspect that the emergency won't be declared for that long. If I were a betting person, I would say the emergency period will last until the middle of July. And 6 weeks after the middle of July is September 1st, just around Labor Day. Okay. If I were a betting man, I would say put your money on that one. It's yet to be seen. The government, I think as of today, as of this week, the government will extend the emergency period until the end of June. That's where we're at right now.
Okay.
All the government would need to do is to push it an extra 2 weeks and then say it's not going to be delayed any further. And then employers have 6 weeks to bring back their staff off from layoff. But Dr. Agatha, that's not the only change that came through. The other change that came through is this. Let's say you're an employer and you didn't lay off all of your staff, but you were required to reduce their hours or reduce their pay. And that could be even completely reduce their pay. Under the Employment Standards Act and the newest regulations that were just passed, those changes to an employee's compensation or hours is not considered a constructive dismissal for the purposes of the Employment Standards Act. So that's again where the government went back in time and they said, well, if you were forced to implement these very tough decisions, and they're not easy decisions to make, under the Employment Standards Act, it's not a constructive dismissal. Now, I'm choosing my language carefully there because there is still a risk that cutting an employee's wages is considered constructive dismissal in Ontario courts.
Right.
That is separate from this. But what the Employment Standards Act is saying In terms of minimum requirements, if you are forced to decrease someone's pay by even a small amount or a large amount, or cut someone's hours, you can continue doing that for the duration of the emergency plus 6 weeks after, and it will not be considered constructive dismissal for the purposes of the ESA. So that is also welcome news for dentists, because it allows, perhaps a dentist wants to open for July 1st, but they don't want to bring back all of their team all at once. They can do that. They can bring back one or two, whichever employees they require for the business, keeping in mind, we're not going to be discriminatory against any group of employee or particular employees. They have that flexibility. So we're currently right now this week in the period where we're in the middle of the emergency. So if a dentist wanted to, they can choose to bring back certain people, but not bring back others. And they have, an additional, well, right now we have 6 weeks plus, the end of June to do that.
Okay, so before we get any deeper, because there's already a bunch of stuff that I want to ask you about, and I'm sure a lot of people are out there wondering this. Number one, there's this thing about, at what point do they lose their subsidy? So the $2,000 everyone's getting, is it up to 1,000 they can earn additionally? Like, how does that work? So that's question number one.
Sure.
And then the other thing I have is, if you want to bring, let's say you have 4 members of your team, can you, instead of bringing back one at a time a little bit, are you able to say, okay, this week you're working, next week you're working, the week after that you're working?
Right. So I'll answer your second question first. So the answer is yes.
Okay.
If an employer wants to come up with an appropriate, reasonable, like staggered return to work policy, they can do that. And for any time that the employee is working, pay them their wages, the same wages that they would have received before the pandemic. If they're not working, they would be considered on a temporary, unpaid leave of absence. And the employer, the dentist, can do that for the duration of the emergency plus 6 weeks. Okay, so yes, and I think there'll be a variety of reasons why a dentist might want to do that. They might not have the same volume of patients as they had before. They don't need 3 assistants. They only need maybe 1 or 2 or 1.5 assistants. So maybe 2 assistants over 3 weeks.
Yeah.
And so that's 100% possible. To go to your first question, how it would affect the government benefits that are being given out and the wage subsidies. So first, let's start with the government benefits to employees. Mm-hmm. So that is limited for employees. It only lasts for 16 weeks. So 16 weeks, if someone were to start getting CERB from the middle of March, they only get it until the middle of July, period. Okay. They are not entitled to any more under the current rules of CERB.
Okay.
And if an employee is eligible for employment insurance, they can apply for employment insurance. And any income they make, when someone is on employment insurance, it does affect, how much coverage they get for that time. In terms of, let's say an employee is currently on CERB, so we're in the beginning of June here, and an employee is on CERB, but they're still recalled back to work. Well, what I've heard is going on is some employees saying, well, I don't want to go back to work this week, because they know if they make over $1,000 in the 4-week period that the government has prescribed as certain CERB periods, then they have to forfeit all of the CERB money.
Yeah, but if you limit it to 1,000 per employee.
Correct. So there would be a way to do that, and it really very much depends on the weeks that CERB is given. So in this first week of June, when I'm talking to you now, this is the last week of the 3rd period, I believe. Well, we're in the last week of the next or the current CERB period. And so as of next week, the employee can make an additional $1,000 and still accept their presumably final payment under CERB.
So you have to work in your first week and not your last week?
No, you can make the $1,000 within those 4 weeks.
Okay.
But it's a rolling 4-week period, and it started in the middle of March. So, if that's something that's the employer and employee would like to work out, they can do that. But if the employee started accepting CERB in the middle of March, they only get it to the middle of July. So CERB is not going on and on and on.
Yeah.
Right? EI might. EI very well may continue during that time, and the government has yet to, clean up and clarify those rules, or what's going to happen if someone was on CERB and then needs to go on EI. They haven't fully clarified that yet.
So
In terms of,
I know you're not a mind reader, but like, what do you think? I'm looking at the why. Like, what is the motivation to make all these changes? What are they trying to do? Are they trying to like build up the economy? Are they trying to help employers? Like, what is the motivation behind it?
yeah, this one, if you ask me, it was definitely to let off some of the steam that was collecting. Because as we talked about it before, and if people have followed me elsewhere online and LinkedIn, they'll know that I've been saying, if you lay off an employee and you don't have any benefits to continue, no employment benefits, the layoff turns into an automatic termination after 13 weeks.
Yeah.
So the government saw that coming. That would have been in the middle of June, right? Because the middle of March is when a lot of these first took place.
My own math, and mine would be June 22nd. Yeah.
Right. So you're buying yourself a little bit of time if you close a little bit later. But the government saw this coming, and they said, well, we need to let off some of the steam and even the government said it in their press release today, which was there would have been mass terminations and all this termination pay and possibly severance pay for large employers that would have to be given to all of these employees. And the employer didn't want to terminate, the employee didn't want to terminate, but the law said it was a deemed termination. So this lets off, I would say, a lot of the steam. So if an employer also kept their employees on but was forced to cut their wages, they have some protection under the Employment Standards Act. It is not a complete carte blanche for an employer to cut everyone's wages, because the rules around constructive dismissal in court still apply. And number two, any changes to employment, whether it's a temporary layoff, a leave of absence as they are right now, or cuts in wages, have to be reverted after no later than 6 weeks after the end of the emergency. So it's a temporary period.
Interesting thing that I heard, and I don't know, I heard it through the grapevine, so I'm not sure how accurate it is, but so after those 6 weeks, apparently I hear that they're limiting the amount of hours that people can work. So I don't know if you've heard this. This is just today.
That I haven't heard about. What have you been hearing?
They told me that they've changed some law this morning that you can only work up to 32 hours a week, which essentially the motivation behind that was to create more jobs in businesses where people are, say, working 40, 44. So by limiting each person to 32, it forces you to create a new position for somebody else. So they're trying to build more jobs. At the same time, they're creating more balance in life, right? Because if you're working like a dog, then you're forced at 32 to stop, then at least maybe you can have a life outside of work.
Yeah. No,
impact, people who have been, for example, like say in my office, somebody who's been, putting on payroll 40 hours a week for the last so many years. And now coming in saying you're topped at 32. Now I can shift my hours to accommodate that, but is this going to be an issue for my staff when I come in and say that?
Right. So what I would say is this: there's nothing in the law that is written that an employer is forced to cap an employee's hours. But if an employer wanted to organize their business in such a way that at that one business, they say, well, we're only giving people 30 hours or 32 hours a week in order to, again, stagger the work, stagger the different workers coming into the operation, that is completely reasonable for them to do. And the newest changes to the law protect an employer doing that for a temporary period of time under the Employment Standards Act. And so, there isn't anything written in the law about a maximum amount of number. But that sounds, that's one way that you could organize your business to make sure that there are fewer workers in the workplace. You're taking all the necessary and reasonable precautions to protect workers, to protect your patients. So that sounds like one idea, and it sounds like a good idea. But there's nothing in the law that caps the amount of hours an employee can work. If you want an employee to work 44 hours a week in Ontario, you can do that.
Yeah, I'm curious. I'm going to ask the person who told me about it because that's an interesting one that would really impact, especially a lot of offices that, have long days or are open 7 days a
Yeah,
week and stuff like that for sure.
yeah.
Okay. I have, okay. Then you were talking about constructive dismissal if at the end of it, people are looking to do that. Because I am hearing a buzz that some dentists are looking to kind of restructure things and potentially, a few people I've talked to basically said, for years I've put up with something and this kind of woke me up. And there's this person in my office that this just kind of pushed me to say enough is enough. How does one do that, with what's going on in the
Right.
world?
So, I mean, how does one do that? They do it very carefully,
Yeah.
right? And with all the appropriate legal advice. So, number one, all the changes that I talked about today, it doesn't change if an employee is, if a business closes and an employee was terminated completely.
Yeah.
Okay. There actually is an exception. And now that you brought it up, I'll talk about this one exception. And there's more detail in the regulations themselves. So I'm happy to, reach out or call or email anyone who has more
Yeah, I mean,
questions
that's
about
a
it.
very individual conversation, 100%.
Yes,
You gotta cover your butt in so many ways. So for
right.
sure.
But let me tell you what it says. If an employer happened to give someone notice of termination, like working notice, say, hey, unfortunately your employment is terminated in 4 weeks. The law gives the employer and the employee the ability to go back and take back that working notice of termination and say, actually, you are on an unpaid leave of absence starting now. So that doesn't directly answer your question, but when you talk about termination, I wanted to mention that. So if a dentist has given notice of termination, paid working notice of termination, the dentist can go back and call it an unpaid leave of absence. We're
So
not going to take any money away, but it's preventing these terminations from taking place. So that's why I wanted to bring that up. So the current rules
I
are
think
trying to prevent, all these terminations from taking place.
I think I'm misunderstanding it because I'm understanding it like you said that if I were to decide to terminate somebody in 4 weeks, I can give them notice now. And
So no, so let me back up because I gave you an answer to a question that you didn't ask yet. So let me first answer your question,
yeah.
and then I'll go to my second question, my own question that I created.
Oh yeah,
Okay?
this gets it's like a blooming onion, man. It just gets
Yeah,
layers
yeah,
and layers and layers.
yeah. So okay, so I'll go back and I'll answer the first part of the first question. So if there's a dentist out there watching this and they feel that,
We need to call you.
yeah,
Number
well,
one.
first of all, give me a call. But any terminations need to be done very, very carefully because the regular rules around termination still apply. There are still minimum amounts of termination pay. There might be severance pay depending on how large your corporation or your corporation is. Minimum statutory severance pay, and there might also be maximum severance pay that the dentist has to pay the employee based on their written contract. And if there isn't a written contract, the maximums are, dependent on several different factors, which have been interrupted because of this COVID pandemic. One of the main factors, if you don't have an employee on a written contract, one of the main factors to determine how much notice or pay you have to give that employee is how easy or difficult it is for them to find a similar job. So if you're terminating a long-term employee without a written contract, the dentist should ask themselves, how long would it take for that employee to find a similar job? That's how many months of pay that employee is entitled to. And courts say it's up to a maximum of 24 months, 1 month for every year of work to a maximum of 24 months. And so it is, if there's an employee that just has not been performing well, I can tell you this, they haven't been performing at all in the past 3 months, have they? So to terminate someone for cause right now for poor performance, significant, consistently poor performance, now is not the time to do that because that will put you right in front of a judge and you will give your lawyer a very difficult time to try and explain to a judge, well, this person really should have been terminated for a good reason. Right now, there isn't a good reason. So if a dentist is considering terminating someone, there are still payments that may have to be made. Minimum payments, yes, and maybe some additional payments that have to be made. So I would say tread very carefully and really consider the fact that these employees are now on an unpaid job protected leave of absence that lasts for right now, until the middle of August, but that could easily be bumped to the beginning of September or past.
So does that time count? So let's say that, let's say I hired somebody right before let's say January, just for simple math.
Yep.
And then we shut down end of March.
Yep.
Are they now employed for 6 months?
Yes.
So the time counts towards the total time.
Correct. And it doesn't have, it has a small impact, but I wouldn't say it has a big impact. The two ways where it would affect an employer is, one, they might be required to give additional notice. But like I said, a notice of termination. But like I said, that is 1 month of pay for every year of service. So an additional 3 months is not going to really change how much notice is given to an employee for termination. But it might also affect vacation allotment. Because back in 2018, you probably know this from your office, if you have an employee who's completed 5 years of service, they are entitled to an additional week of vacation. So a minimum of 3 weeks of vacation. So if there's an employee who passed the 5-year anniversary mark, they've completed 5 years of service during this COVID period, they are entitled to an additional week of vacation.
That's funny.
So the time clock, it's just when an employee is on a family medical leave or a pregnancy leave or parental leave, their tenure clock doesn't stop. They're not being paid wages. It's an unpaid job protected leave of absence. So they don't get any money. You do not have to continue benefits during that time. Although if benefits were continued for this layoff period, it's best to keep those benefits continued. Don't take away something from an employee if you're switching them from this layoff to a leave of absence. That is a no-no. But you don't have to give anything extra, like termination pay. That was the biggest takeaway, or one of the biggest takeaways from these changes to the law. And here's another thing that I was thinking about when I was reading over this legislation on this cold weekend that we had here in Ontario. The government has said if you laid off an employee, they were actually on an unpaid job protected leave of absence.
Yeah.
That means they weren't already on a layoff. So if you take a very strict reading of the law, and again, I would tell all dentists listening to this, consult with an employment lawyer, including yours truly, before you do this. But once the emergency is over, and then 6 weeks go by, technically under the law, those employees have not been on any layoff. So an employer would be free, subject to the Employment Standards Act, subject to their written employment contracts, which hopefully has all the right terms, could place that employee on a new, for the first time, temporary layoff, which cannot exceed more than 13 weeks. So there is an extra pillow that's built into this. Because the employee was not on a layoff before, they could be placed on a layoff again. So there's some extra time.
Twist.
Sorry?
That's a very interesting twist.
Well, the government has declared all of those layoffs to actually not be layoffs. So if you've never laid off an employee, you have the business reasons to lay off an employee. We don't lay off employees because they're not performing. Yeah. We don't lay off employees because they came in late. That's not how it works. We lay off employees because the patients aren't there, the cash flow isn't there, the revenue isn't there, or you're forced by government agencies to shut down. Those would be the reasons for a layoff. So if a dentist is listening to this, let's say the beginning of September, saying, well, I don't know how I'm going to bring back my staff, all of my staff, my full complement, all the assistants and hygienists and receptionists, treatment coordinators, office managers, right? I can't bring them all back. Well, if an employer is required to lay off employees because of a slowdown in business, get an employment lawyer on the phone and understand whether you can lay off those employees because of a slowdown in business after the pandemic has been, declared over and after 6 weeks has gone.
That is actually a very important thing that you just said, because I think it's going to allow a lot of dentists extra time to breathe and build
Yes.
that probably most of us didn't know about. So this is huge, because to know that there's, when this is all done, there's still the potential to maybe potentially extend it a little bit longer, give ourselves a little bit more breathing space. Huge, huge, huge. So I hope
That's right.
we can do this, because that's a massive one that for me, I had no idea.
Right. And there are plenty of rules, like we talked about last time. There are plenty of rules regarding layoffs. There are ways that you can get a longer layoff than 13 weeks. There are ways that you can lay off an employee for 6 weeks at a time, bring them back for 2 weeks, lay them off for another 6 weeks, bring them back for 1 week, and then lay them off one more week. You can do that too. It's a 13-week layoff is 13 weeks within a 20-week period.
Yeah.
And if benefits of employment are continued, including health benefits or any benefits of employment, that layoff can last to 35 weeks within a 52-week period, as long as there are certain very specific conditions that are met. So I think, the fact that the government has said the COVID layoffs are actually unpaid job protected leaves of absence, it releases so much of this pressure that was building. I was hearing it from plenty of dentists and all sorts of employers. I actually sent, a couple emails to the Minister of Labor himself and his assistant, and I was also in touch with some other people at the Ministry of Labor to say, employers really, need to know how the government is going to deal with it. Other provinces dealt with it in different ways. Yeah. British Columbia said, we will extend the length of layoff from 13 weeks to 16 weeks.
Yeah, it's not a lot.
Ontario, no, it's not. And that would push you to the middle of July. Ontario didn't take that route. Ontario took a very different route. And
I feel like this is also a really good thing. And I know a lot of employees won't view it that way at the beginning. They'll think like, oh man, more time off and you don't want me back and all this stuff. But in reality, it actually will probably preserve a lot of jobs where we would have been forced to let somebody go. And then once we let them go, we just make it work with the number of people we have or get.
That's right.
Whereas now it allows these people to maybe stick around so that we can get our stuff together. We've got time. And now, let's talk about you coming back and how that's going to look. But at least there is a potential to have your job back that you didn't have when you were terminated.
Right. And the government has never guaranteed economic recovery around the province. I mean, this will take time. Yeah. And it's going to take hard work. And there will be some hard decisions that have to be made as well. And with these new changes that brought in, I completely agree that there's a little more flexibility for employers to preserve jobs and get their businesses up and running. And the other thing is, like I mentioned before, I talked about employment insurance. The government introduced CERB very quickly. And they still have not fully clarified the interaction between CERB and EI. The government could easily say, listen, if you got CERB, it doesn't affect your EI. Or the government may say, if you got CERB, that counts as EI. Right. Because if someone is laid off, if they've paid into employment insurance in Canada, they are entitled to be covered for a decrease in their earnings. And that's the country we live in. So if a person were to be laid off, there are certain supports in society that can help them. But I agree with you completely. Like you said, it preserves jobs and it supports the recovery, which will help everyone.
So I want to take you in a slightly different spin. Sure. So now we've talked about, us choosing to bring people back. Now our people may say, listen, I have young children at home or elderly parents or immunocompromised people. I don't feel safe coming back. What happens there?
Right. So number one, I would hope that the dentist has read I think it's 65 recommendations. How many recommendations is on that? There are many guidelines and recommendations. There are a lot. I think there's I haven't even fully read them.
There's a lot.
They're hot off the press.
Yeah.
So number one, I would hope that the dentist has reviewed and implemented all of those recommendations. That's going to be key.
Assuming everything is there, all the people, all the rules, everything's done, but somebody still says, still exposure, don't want to come back.
Right. So the one thing I want dentists to remember is this. They have obligations for occupational health and safety. And their main obligation is to provide all reasonable protections for workers in the workplace. They have an obligation to do that. Now, I didn't say every possible precaution.
Yeah.
I said all reasonable precautions. That's what the employer must do. So for dentists, I think the college has fortunately, provided, more detail the better, because if a dentist is going to say, well, what do I know is reasonable and what is not reasonable? A construction site is a lot different than a dental office. And now we have some very clear guidelines, from the regulatory body that says, this is what's reasonable. Anything that isn't this is not reasonable.
Yeah.
So if an employee says, well, essentially what you're talking about there, Dr. Agatha, is a work refusal. So an employee says, I refuse to do work because I believe it's unsafe. If the employer can prove that they've taken all the reasonable precautions to protect workers and patients in the workplace, the employee would have to, well, in my opinion, it would be very difficult for a dental office worker to prove that their work is unsafe. Okay. And there's an investigation that the employer can do at the employer level. There can also be the Ministry of Labor that can be involved to determine, okay, is there a genuine concern? Is it a genuine belief of the employee? Or is it, there's two parts to the test. So a genuine belief that something is unsafe, okay? And it can't just be something that they believe or it's a feeling. It has to be genuine, okay? Based on the circumstances. And number two, it has to be likely to endanger the employee. So a genuine concern, and it has to be likely to endanger, considering all of the precautions that a dentist would take. So every work refusal is going to be judged on a case-by-case basis. Yeah. But I think if a dentist has proof that they have followed all of these recommendations from the regulatory body that permits dentists to operate, they're going to say, there's nothing more that we could do. This is everything that's reasonable. Again, they don't have to take every single precaution. They have to take all reasonable precautions. So that's why I started with following the RCDSO, because if you get a work refusal, you hold up the RCDSO guidelines. You say, this is what we implemented. This is not likely to endanger your health. A risk with precautions and mitigation is not the same as likely to endanger, right? That's a relatively higher test. So, I mean, if an employee finds something, maybe a dentist is unaware of a certain safety deficiency in the office. If that does happen and it can be remedied, that still doesn't permit the employee not to come into work. So in cases where I've helped dentists with that, number one, it's ensuring all the precautions are already taken. Two, ensure the employee knows what those precautions are and hopefully can see it.
Yeah.
Because you're also going to want those employees to train your patients and explain to your patient. Yeah. And number three, they need to clearly state their work refusal. They need to say, I mean, and in writing is better to say, I don't think it's safe because there's a risk and I have young kids at home. It would be investigated. Now, all that being said, there are also, we talked about the leaves of absence. There is a special leave of absence under the Employment Standards Act for someone who has to take care of kids at home.
Yeah.
So we have to be careful when an employee is trying to say they don't think the work is safe. If they're saying, well, listen, I have kids at home and I have to take care of kids, that's different than a work refusal. But if they say, well, my husband believes it's unsafe for me to come into work, so I can't come into work, that's different.
So I want to sidetrack and then come back to this, because one thing you said right now that just got me thinking, there's a lot of people now that have switched to working from home, right? So the one spouse is now working at home.
Yep.
Schools are closed. A lot of daycares closed. and the other spouse is now looking to come back to work in a dental office and says, young kids at home, husband, wife has now come to work at home and is now working from home, which means they have to take care of our children because we don't have anyone else to help. So I can only come in, from 9 to 10 and from 4 to 5. I'm just throwing stuff out.
Mm-hmm.
Is that refusal to work, or is that I got to work with this person around their children and their schedule?
That is more on the accommodation side than the work refusal side. The work refusal side is I am not completing those job duties because I believe the work is unsafe. What you've described there is someone who says, I have child obligations. I can't complete all of my job duties, but I can complete some, and I require accommodation because of that. So that means the employer is obligated to work with the employee, come up with a specific accommodation plan for a temporary period of time. We're not talking about permanent changes. We say, you sit down with the employee, and I frequently help dentists and employers with this too. You sit down with the employee and you say, well, what is their accommodation that they require? Well, this is the accommodation that the employer can give. Let's meet in the middle.
Yeah.
And that's essentially the accommodation process.
This is a common one. I feel like I'm hearing a lot more buzz around, one spouse staying at home, and they're like, wait a second, I haven't been watching the kids all this time. I've built this business now and I can't watch the kids, and send them off to somebody, and you can't because no one will take them now.
Right. So I've been helping employers throughout this pandemic time as well. We have to, every case is different. Mm-hmm. And we treat every case differently. So I'm giving kind of general guidelines here. But if there's an employee who says, well, I can only work 9 to 10 and 4 to 5, well, that may not be reasonable for the employer. Okay. And there are some judges in Canada who, with regards to family status and accommodating someone and their child care needs, or even elder care needs, there are some judges in Canada who say the employee has to show how they are trying to help themselves.
Okay.
But there are some adjudicators in the province of Ontario who disagree, who say, no, it's not appropriate for an employee to have to tell the employer, this is exactly what I'm doing at home to take care of my kids. But I think this pandemic has changed things, because if there is someone at home who can look after the kids, the question will be, does the employee's children require 2 parents to be at home while they're being taken care of? Mm-hmm. Now that's digging a little bit more into how the employee is self-accommodating. And there are some adjudicators in Ontario who say that's not part of the accommodation process. But there's some judges in the federal court of Canada who do agree with that. And so ultimately it comes down to what is reasonable in the circumstances. And if it's possible, one type of arrangement you could come up with an employee is, okay, how about for one day you have your spouse look after the kids? Now, every other day, your spouse can try and look after the kids, and then you can be at home. So can you work at least 2 days a week? Because what I see you laughing there. These are the types of...
We've gone from lawyer to marriage counselor to freaking therapist. Like, this is crazy.
I do it all. Okay, I do it all. But those are the types of conversations, and they're constructive conversations. There's no accusing the employee of anything. The employer at that point, when the employee says, I have childcare needs, I want to work, I just have these childcare needs, it's important to work with the employee. So, that's just one example. Another example could be, well, can you work half a day? Can your spouse, cover you from 9 until 1 for every morning? Maybe mornings are better, maybe mornings aren't better. Maybe the dentist wants to open up some overnight dentistry while kids are sleeping. No, a dentist does not have to change their hours to accommodate an employee's request for childcare accommodation. But it's a collaborative approach. And there's no one size fits all, because every person is different and every employee has to work individually with those employees.
Our grandparents are like,
but accommodation is, it's never, well, no, sometimes it's straightforward. If someone says, I have a bad back, I need an ergonomic chair. Great, that can be done. But when someone says, well, I need to adjust my hours because of elder care, I need to bring meals to my parent every day at 4 p.m., and it takes me an hour to drive there, an hour to drive back. So I have to now finish work at 2:30 so that I can go home, get the lunch, So it becomes more complicated, but, I think it's because we live in a compassionate society, and, there are those protections that exist in the law.
Yeah. So, okay. So back to where I was asking you about whether a staff member doesn't want to come back.
Yeah.
One of the things that has been an interesting development this past week is that the RCDS has different rules than the hygiene.
Yes, I heard about that.
So now, under our new rules, we have less restrictions than the hygienists. And the discussion is what should happen and what's the right thing to happen, and what am I responsible for as a dentist? And can I say, if you are required to do something extra that I am not, then at what point is it my governing body, my office, versus you pay for your own additional, or do I have to provide it? Like, this is just where this is the past week, and it's been all over. Everyone's like stirring around it.
Yes. Yeah. So number one, the first thing that comes to mind is those two professional bodies need to get together and collaborate on reaching kind of similar standards, because it will only lead to, at a minimum, discussion, which I think is fine, but it probably would lead to conflict. Absolutely. In the dental office. Because listen, a hygienist is a regulated health professional. They have duties to their college. Mm-hmm. You can't get around it.
Yeah.
Dentists also have, obligations to their own college. So I think, one part of me wants to say, well, whichever of the two are more restrictive, that's probably the one that should be done. Okay, until whatever is more restrictive is changed to kind of match.
So if you price out PPE right now at this, and I know the prices will go down, but currently, and you can't even get it anywhere. I mean, I have a few left over, but very few people can get their hands on it. By the time you add everything together, including masks, shields, everything, you're talking $48 per person per patient, yes. Right? So if you're talking a typical cleaning, and we are told we're not required all this stuff, but they're told they are required, what happens to the $48?
Right. So I don't have an uncomplicated answer for that question. Do you want to know what my answer is?
Yeah.
My answer is, this brings up the age-old debate of independent contractor versus employee. Okay. And that's one way that I look at this. So if your hygienist, if a dentist listening to this, if your hygienist is a contractor, then that contractor should be responsible for all of the tools mm-hmm. that they need to complete their job. It was uncontroversial in the past because the dentist would supply that, rightfully or wrongfully, the dentist would supply that. Well, now we're coming face to face with this decision and a choice that the hygienist has certain obligations they have to follow, but the dentist was never required in the past to pay for those. Mm-hmm. And for those hygienists who are contractors, they should be paying for their own tools, period. A lot more than just PPE, but that's maybe a topic for a different discussion. Yeah. But for those hygienists who are employees, that's where I'd say, well, and number one, we need to get these governing bodies to consolidate and to make it clear what it is, because I think dentists will be on the losing side of that argument, because dentists don't regulate hygienists. Yeah. And that's the reality. But they work with a very close symbiotic relationship. And so I don't think this should push anyone to start arguing or start breaking practices apart. I think there has to be a happy medium found, and there's not an easy answer. But because here's the thing, the hygienist, it comes down to their own professional responsibilities. And if they need something to complete their work and the dentist normally provided it before, well, there might be an argument to say the precedent has been set. The dentist, the employer has to provide it. But I know a lot of, so that's a little harder pill to swallow. But if the hygienist is a contractor, it's a lot easier for you to say, this is a tool that you need for your job. If you're a contractor, you're making your own money in your own business, there are many costs to business. And the opportunity to make a profit and the risk to make a loss is a main part of being an employer. So is, the tools that they use for their job. So if they aren't making as much money because of, an important change to their business, they have to eat those costs as contractors. As employees, it's not as clear. I may have touched upon the wage subsidy. What I'll say about the wage subsidy is this. It has been extended, I believe, till the end of August. Remember what I said about beginning of September, right? Governments talk. They know, and I suspect end of September. And if, so the wage subsidy, the regular rules as of right now still apply. If there's at least a 30% drop in revenue, you can have a portion of your employees' wages backed by the government.
Okay.
And that is if they're working or not working, right? That's been the terms of the wage subsidy from the very beginning. So you could, if you wanted to, you could pay all of your employees their regular wages and then call them in when you need them, maybe on a staggered basis. If you're going to go for the wage subsidy, that would help.
Can you get some on the wage subsidy and not others?
Yes. Well, I mean, if you are applying for the wage subsidy, right, there's no maximums on the wage subsidy, maximum amount of employees that you can put on the wage subsidy. So if you're bringing back an employee and you are eligible for wage subsidy, you could put all of them. I mean, I think it would make financial sense to put all of the employees on wage subsidy. But if you don't apply,
I'm thinking of the larger offices where they have like many employees and it won't be effective, but they could bring some back. Would they be able to bring, like, let's say an office that has 25 people, can they bring in, 10 now, put them on wage subsidy, but the other ones stay off?
Yes. Oh, of course. I mean, for whatever wages those employees are paid, let's say you bring your team 1 on the first week, team 2 on the second week, team 3 on the third week, team 4, they can all be put on the wage subsidy.
Yeah.
Because it's a percentage of the wages that they earn up to a maximum of $847 a week. So if you only pay the employee $500 in the week, the government will give you 75% of that. And if they only work 1 week, well, that's all you're going to get. 75% of what you paid up until, the government contributing $847. So yeah, that's 100% possible. And again, that also assists. And that's the federal government, provincial government working together to say, let's support businesses. So that's what the most recent changes to Ontario employment law, works together with the other supports.
So the other thing I'm hearing is that a fairly significant number of dentists have filed for bankruptcy. So I'm guessing they're shut their doors. What happens to, I know they're not protected from termination, but how does that play with all this?
Yeah. So I work with another lawyer at my firm on the insolvency side. And what I'll say about bankruptcy and employment law is this. There are still minimum amounts that must be paid to the employee, regardless of if you're in bankruptcy protection or complete bankruptcy.
Right.
Minimum termination pay is sacrosanct. So a termination pay under the Employment Standards Act, that must be given. Mm-hmm. All accrued wages must be paid to the employee. That includes accrued vacation pay as well. That must be given to the employee. Mm-hmm. And they would go, if those aren't paid to the employees step to the front of the line to be paid any of those things that I just mentioned. Other entitlements that the employee may have, an employee would become an unsecured creditor and they would be part of the insolvency process. They would take part, with the licensed insolvency trustee and participate if they do have a claim against the company. So Fortunately, I haven't helped any dentists with that, but I've helped other employers along with my colleagues to uh, help a business understand what are their absolute minimum obligations, what are possibly the maximum obligations, and what should we do. And the reason why, Dr. Agatha, those amounts are so important are this. Those minimum termination pay under the Employment Standards Act, minimum wages, accrued wages, and accrued vacation pay, if those aren't paid to an employee, the employee can sue the director or directors personally for those amounts. So there's, under the Employment Standards Act, if those amounts aren't paid, an employee is permitted to pierce the corporate veil, go past the corporation, and go after the director's house, the director's car, in litigation if those amounts aren't paid. So, there is a lot of work and planning that goes into any employer considering entering into protection, how it affects the employees, how it affects the leases and their other, rents and agreements that they have. So I know, it's not the best situation, but the whole purpose behind bankruptcy protection is to get out of bankruptcy protection and renew and move on. So, I'm happy to go into more detail if anyone watching this would like some more information. And so there are some minimum requirements we have to be careful of, but otherwise, employees, become an unsecured creditor.
So basically, the one message that I constantly hear is like, don't do anything on your own until you get some professional advice, because this stuff, as complicated as it is way more complicated when you try and handle it on your own. Kind of like doing your own teeth, right?
Oh my gosh.
Let a professional handle it before you act.
Right, exactly. And the other thing I would add is the law in this pandemic, in this state of emergency that we're in, it changes at a pace that has never been seen before, in my opinion, has never been seen before. Yeah. Right? I mean, the regulations were dropped on a Friday afternoon, and they actually even assigned a title to the regulation. Normally they give it a name. It was the name undefined. And I haven't checked today whether or not it's been updated. And then the RCDSO, on a Sunday night, I heard about that too. On a Sunday night, I think they just wanted to keep it in the month of May, I guess. I don't know. Oh. On a Sunday night, they released the updated guidelines. So I would agree with you. The only things I do to my teeth are I'll floss and brush, and maybe I'll do some occasional whitening. And I think that's good for an employer to do. But if we're talking about root canals, or I can't do my own Zoom whitening. I don't have all the stuff at home. I need to go to a professional.
Don't try this at home.
Right. So yeah, and there are, I'm always happy to chat to any dentist who wants to talk about employment law.